what happens when we get bad law or we don't like the law that's out there. All right, hopefully you read the case of Trentadue v. Gorton, and the facts are fairly straightforward. You've got this woman named Ebby who's murdered in a rented home. Now, one thing about the law is that cases always follow lawsuits, always follow the money. So you try to go and sue the companies involved, those who have deep pockets. So this case, there are a lot of people being sued. What we find out in the case is that she's murdered by this man named Gorton. Now they find this many, many years later. They discover this almost 15 years later that Ebby was murdered by Gorton based on DNA evidence. Her father, Trentadue, is the one who brings the lawsuit. So he sues all the parties involved. He sues Gorton's family that owned the sprinkler company, and Gorton, if you remember, he entered based upon he had access to the home because he worked for the sprinkler company. They sue the one that she was renting the home from. This is a civil lawsuit, okay? And I want to draw a distinction between criminal and civil lawsuits, all right? We've got criminal, which when in a case like this, you have a criminal case and murder. The ones who bring that case are the state prosecutor or a federal prosecutor. So that's a prosecution. You have criminal charges, and what's at stake is your liberty or your life, right? You could be jailed. You could be put to death for a murder. So on the other side, we have the civil case where you are suing for monetary damages. So you've got the state that brings these cases that are you going to go to jail or not? What is your punishment going to be? And then you've got the family that can bring cases and say, we've lost our daughter, we had pain and suffering, we have maybe expenses to care for children, to take care of, to value what this person's life was. And so we're going to sue in the case of murder. You have murder on the criminal side and then wrongful death on the civil side. So we have a wrongful death lawsuit here being brought in the civil case. So someone is guilty in criminal court, they are liable in civil court. This is completely a civil case. At this point, I assume that there's already been perhaps a criminal aspect to this brought, or that it's being reopened. We have what's called the Statute of Limitations. And we don't want people to wait on lawsuits. And so for instance, if I were bringing a civil lawsuit over a copyright issue and I saw somebody who has violated my copyright, I might wait and see if they made a lot of money with it and wait 10, 20 years and then sue and try to get all this money after they've done all this work, right? We don't want that to happen. If you want to bring a lawsuit, we want you to bring it right away. So we have the Statute of Limitations. And that encourages people. It says, when an issue happens, you have a certain amount of time, in this case 3 years in this matter. You have 3 years to bring the lawsuit, and if you don't bring it within 3 years, you're out of luck. Sorry. So in this state, at this time, when the case happened, there was a state statute that said the statute of limitations is 3 years, and it happens from the time of the incident. So when the murder happened, 3 years after that, in 1986, when 1989 rolls around, sorry, it's too late. You can no longer bring a wrongful death lawsuit. You can no longer ask for monetary damages. So here we are. The matter is whether Trentadue should receive these wrongful death damages so much later. Now, again, he didn't know. There was no DNA evidence available, no way to link Gorton to the trial, to the murder until this time. So what do you think? What's your gut instinct on this case? Do you think that he should be able to bring this wrongful death lawsuit now, or is he just out of luck because Mr. Trentadue, that's what the state statute said? Well, I think generally we say, well, look, if you didn't know about it, if this is new DNA evidence, there's no way we could have known in 1986 that Gorton committed this murder. So it doesn't make any sense to bar him from it. It should start when we find out. That's what has happened for the most part in the criminal side. Again, this is the civil side. So we've got this statute in the books that says it. And I think, at least to me, that just feels wrong. So we've got the common law. What judges want to do is to extend this and say, hey, let's let it start in 2002 when the DNA evidence is found. But we have a clear state statute. And this is a lot like the Buck versus Bell case. We have the state statute and it was upheld. Remember, we have the common law. We talked about that in a previous class. The common law is when judges are creating law over time. It's evolving and they're making decisions and they're creating precedent. And what judges created over time was the discovery rule, that when the elements of a cause of action or a crime could not be determined at the time, it's the discovery rule allows the statute of limitations to begin at the time that the true facts could be determined. Right? So in this case, it would be from that 2002 point on. So the trial court wants to apply this. The problem is that in this state, we have an actual statute that says the statute of limitations begins clearly at the time that the cause of action occurred. Right? When the murder happened is when the statute of limitations begins. So in this case, we've got this conflict of an actual statute addressing this issue, and the Court of Appeals has to deny the discovery rule. So what's the answer here? What do we do when we feel like the law is wrong? And this is a case where it feels like the law is wrong, right? So what you do is you go to your state legislature and you change the law. You write a new statute that says, hey, in 1986, we didn't know a lot about DNA evidence. There's so much more that's happened. This is a field that's changed. And let's have a new law that says when DNA evidence is found or when we can determine a crime happened, even in civil cases, this is when the law starts. This is when the statute of limitations begins. 3 years kicks in 2002. So when we have a conflict of law, we have what judges want to do is in conflict with a state statute, the statute wins. If you don't like the law, you go and write a new state statute. You get your legislators together, you go, you bring it before the state house, state representatives, and you enact a new law.